So we have some breaking news out of Georgia for you, where Judge Scott McAfee has ruled Fulton County District Attorney Fani Willis can continue to prosecute former President Trump's election interference case. So I want to bring in CBS News campaign reporter Katrina Kaufman to explain this decision. Hey, Katrina, I know you got your hands on the decision. I've been trying to go through it as quickly as possible. And it looks like a part of what we're seeing here with the judge's explanation is that he kind of did not buy that she benefited substantially in any way from the relationship. But I know you've been poring over the document. So what are we learning?
Good morning, Anne-Marie. I'm still reading it myself as well, but you're right. It looks like the judge found no actual conflict of interest here. He doesn't think that Fani Willis has a financial or personal stake in the way this trial is going to proceed. But he does say that there has to be a different way for this to move forward because there is still the appearance of impropriety, and that could affect public confidence in this trial and in the justice system itself. So either Fani Willis has to step aside or Nathan Wade, the special prosecutor that she had a romantic relationship, needs to leave this case.
Oh, that's really interesting. Okay, I want you to sort of stand by for us because we have other questions for you, but we've got a few other people also hanging out. CBS News Justice Department reporter Robert Laguerre is also here. I know that you have been going through the paperwork. So this is interesting because I've only kind of gotten to the page number 8 on this. And so I didn't see that other element that perhaps someone's going to have to step aside, if perhaps Nathan Wade, because the public appearance also is important here.
Right, yeah, so it's on page 17, the bottom of page 17. I was looking for it myself. So we can just read it here if you want. The district attorney may choose to step aside along with whole of her office and refer the prosecution to the prosecuting attorney's counsel, which would reassign that matter. Or alternatively, she says the special prosecutor, Nathan Wade, can withdraw, and this is a key quote, allowing the district attorney, the defendants, and the public to move forward without present or remuneration, distracting from and potentially compromising the merits of this case. So the distraction and the potential for compromising is what the judge here is saying is the most important thing, and that's why he's offering this binary choice to the prosecutors.
This is interesting because we know that Fani Willis actually offered the job to someone else before Nathan Wade. That person turned it down. It wasn't so easy to find someone to take this job. Do we have any indication how long Willis might have to make a decision?
So the judge does not actually say this in the order. What we do know is that there are obviously pending motions before the judge that have to do with this case and other defendants, and so likely there will have to be a choice to be made before the case moves forward. We're not sure exactly what the timing is and what this means for the calendar of this very complex case, but right now the district attorney and her special prosecutor have this choice that they have to make.
Okay, let me sort of bounce back to Katrina now. I'm going to try and bounce between the two of you because I know both of you guys are going through the paperwork here. Katrina, what I'm going to ask you to do, because, you know, we here have been sitting and watching hours of this case, but I want you to kind of remind us of the arguments on both sides, what the prosecutions were suggesting and how Fani Willis was defending herself.
Sure, there is so much that happened at these hearings, but to distill it a bit, basically, Fani Willis was accused by one of the defendants, Michael Roman, in the Fulton County case, of having a romantic relationship with Nathan Wade, a special prosecutor that she had hired. Judge McAfee ended up holding a series of hearings about that, where it came out that, in fact, they had this romantic relationship, but the real issue is that they were saying that she financially benefited from it. Wade and she went on numerous trips together. They were saying that he paid for these trips with money that he was receiving from the state. And so they both had a vested financial interest in moving this case forward, in prosecuting a higher number of defendants. And that is really a big issue here because it meant that she might have a personal stake in this prosecution that they said created a real conflict of interest. Now, on Fani Willis's side, they ended up admitting that there was, in fact, a romantic relationship that ended last summer, but they say she had no financial stake here, that actually, when she went on these trips with Nathan Wade, she always paid him back. She paid him back in cash, which became a sticking point at the trial that they debated quite a bit over, but that there was no actual conflict of interest here that impacted the prosecution of this case or the charges or anything about it.
Yeah, part of what she was sort of arguing was that, you know, when we went on these trips, maybe I would pay for the tickets and he would pay for the hotel, or maybe he would pay for a good chunk of it, but I would reimburse him in cash because I kept a lot of cash in my house because my dad always told me I should keep cash in my house, which certainly seemed a little odd. And the court kind of recognizes that. And, you know, the judge writes, such reimbursement practices may be unusual, and the lack of any documentary corroboration understandably concerning, yet the testimony withstood direct contradiction, was corroborated by other evidence. So, I mean, the judge essentially believed her, but still suggested that that may not be enough.
Basically, this just created a shroud over this case. And one moment that I really remember was when Fani Willis was on the stand and she said to, I think it was maybe Ashley Merchant, the defendant that accused her as attorney, you know, you seem to think that I'm on trial. I'm not on trial. Your clients are on trial for election interference. But basically, this whole soap opera has been in the media. It's been in the public eye, and it could potentially influence the jury pool.
All right, stand by, Katrina and Rob, because Jessica Levinson is joining us now. Jessica, it's really good to see you. So before I sort of dig into specific questions, I just want to get kind of your overview. Is this what you expected the outcome to be?
This is about what I expected. I did not think that he would find an actual conflict of interest, but there was enough discussion during the hearings where he asked a couple of times, but isn't an apparent conflict of interest a problem, that I thought we could potentially go there? If it's okay, I think for me, this is the crux of the decision where he says the appearance standard recognizes that even when no actual conflict of interest exists, a perceived conflict in the reasonable eyes of the public threatens confidence in the legal system itself. And to me, that's what this entire ruling is about. It's saying, I will not preside over a case where the legitimacy of the case is in question. And he has given the district attorney, a decision here. He said specifically in the ruling, this is a judicially crafted remedy. It's not clear exactly what has to happen in the case of an appearance, but I think this is one that makes sense. He's saying one of you needs to step aside because having both of you on this case will threaten the administration of justice. And he has some great language here about even when an attorney is guiltless in the actual sense, and I think that's important for the public to see, nevertheless is required to stand aside for the sake of public confidence. This is all about ensuring that when we look at this case, and we look at how and when it proceeds to trial, that we feel confident in the process.
I wonder, though, if in saying that, I do not believe a conflict of interest was proven here, yet I do suggest that somebody step aside. It's almost reinforcing the assumption that people could perceive this as tainted in some way.
It's a great question. I mean, my initial response is when I teach in other areas of the law, for instance, when I think about campaign finance law and corruption, the law often recognizes even when there's no there, we want to use a belt and suspenders approach. So there isn't the actual conflict, but we want people to feel, in that case, confident about our election systems. And so we're willing to, I think to your question, have the kind of potential harm of people thinking, well, then why does there have to be a disqualification if there's no actual harm? We're willing to deal with that because we think the greater harm is leaving questions in the minds of the public. I will say the fact that the hearings happened, those questions are already there. So I think in the administration of justice, for public confidence, understanding that the legitimacy of the judiciary is under assault and under question, in my mind, this was the safer route.
Interesting. So, you know, what we have seen a lot with attorneys for the former president and the others is, you know, often there is an appeal, there is something to sort of drag things out. in a case like this, which I haven't seen anything like this before, but I'm not a legal person. Is there wiggle room? I mean, could we see the attorneys for the other defendants say, well, what about this? Could they come back with some sort of appeal insisting that there is cause to have Fani Willis removed?
I will say never in the sense that could there be a defense attorney who's looking at this 23-page ruling and says, you know what, I think actually there is an actual conflict and it's worth going up to the appellate court? Maybe, but let's remember that what Judge McAfee did here is make a number of factual conclusions, and those are entitled to deference almost always when it comes to an appellate review. The appellate court is supposed to correct legal errors, but when it comes to the fact finder, that's Judge McAfee, the appellate court is supposed to acknowledge we weren't the ones in the room. We weren't the ones actually overseeing that hearing. So my guess, and it's difficult to put myself in the minds of those defense attorneys, of all defense attorneys in this case, is to say that this is a win for them, that it's a win to, and this is to your previous question, it's a win to have a judge say, we need to make a change. It's either the district attorney or it's the special counsel. And you bet that the defense attorneys are going to bring this up to the extent that they're allowed by the judge over and over again in a jury trial.
Interesting. All right, Jessica, you stand by. I'm going to bring in congressional correspondent Scott McFarland. So, Scott, what are the chances that we could see the Fulton County case move forward before the election at this point? Because someone's got to step down. We already know that it was difficult for the district attorney to find someone to do the job that Nathan Wade agreed to do. And if you look at the documents here from the court, the suggestion is he's working for a lower wage than most attorneys in Atlanta would. So it may take a while for her to find a replacement if that's the decision that she chooses.
There seems to be this sense, Anne-Marie, this was an efficient ruling by Judge McAfee. But look at all the time that's been burnt on the arguments over this singular issue raised by one of Donald Trump's co-defendants in the case. And look at all the time that's expiring in the courthouse in Florida, in New York, and here in Washington, D.C. Each of these 4 criminal cases against Donald Trump has had some number of delays or time schedules that have been altered by pre-trial challenges. This one was effective in slowing things down, just as the challenges in Washington, D.C. have been successful in slowing things down. And in New York, yesterday, even the district attorney agreed to push back the trial as much as a month into April at the earliest. Donald Trump is now the presumptive nominee of the Republican Party. There's a narrowing window until the general election, and all these legal cases, all the legal jeopardy in which he finds himself, is being stretched out. It seems increasingly unlikely that case in Georgia, the case here in Washington, or the case in Florida gets near a trial for the election.
But how likely is it that if he hasn't put a post on X or Truth Social or anything yet, he's probably going to. How likely is it that this ruling will somehow sort of weave its way into the former president's campaign?
Well, he's been weaving the legal cases into his political strategy from the jump. It's become synthesized into the same thing. He was in the courthouse in Florida yesterday for a hearing in the federal classified documents case. He wasn't on the campaign stump. He made it a point of being in the courtroom for an appeals court argument here in Washington, D.C., when his presence was not required. So if he's blending these legal challenges with a political strategy, potentially effectively, I would think the statement from Donald Trump on this is imminent, if not likely.
Yeah, that's actually a great point, because I thought to myself, as all these legal challenges get pushed along the calendar, he's actually losing opportunities to get in front of the camera and plead his case on many levels. And so when he showed up in court when he really didn't need to, I thought he's going to take full advantage of any opportunity to make an appearance. I'm going to pivot over to Scott. I don't know if you can still hang out with us or if you got stuff to do, but I'm going to pivot over back to Jessica, because Jessica, I want to talk a little bit about the importance of this case because it's happening on the state level. I don't think we've really sort of visited that yet. A lot of these other cases that the president is dealing with, whether it's about January 6th or it's about the classified documents or federal cases. But this is happening at the state level in Georgia. If he was to win the election in November, and this case is still dragging on, I mean, do we have any idea what that looks like for a sitting president?
Well, we don't. We've never been here before, and my sense is that that's a good thing. We've never had to be here before, but I would say I don't know that this case would continue. I know this is a state case, and so the big difference to your question is that as President of the United States, as head of one of the federal branches, he cannot say to his attorney general, now go to court and ask to dismiss this state case. He can for the federal cases. He can't, if he's convicted, attempt to self-pardon, because again, this is a state case and it's just up to a governor to provide clemency or a pardon. But what I would say is the reason I don't think that we would see an ongoing state criminal trial if the former president does win is because I think his team will make an argument that it violates the separation of powers and that it's improper for the state executive, for the district attorney to move forward on this criminal case while he is the sitting chief executive, that it will interfere with his constitutional duty to take care that the laws are faithfully executed, to quote the Constitution. Now, that doesn't leave us an answer for what would happen between November and January if he wins the election. But I do want to caution people, just because this is a state case, it doesn't mean full steam ahead. There's nothing that he can do to prevent it. I think we will see new arguments dealing with different constitutional concerns, structural concerns about the separation of powers and separate sovereigns.
And prior to this, we saw a couple of co-defendants, at least two, maybe three, actually plead guilty. And at the time, we wondered whether or not this was sort of the beginning of the dominoes falling or not. But I assume that this case kind of slowed that down. Do you expect that now we're going to see, the rest of the defendants start to figure out their own personal strategy, whether it means pleading guilty or testifying or whatever it is?
Absolutely. A lot of the people are going to go to it's a great question, going to go to the district attorney and say, once this case really continues, what's my deal? Is there a deal here? And what can I do to avoid jail time if that's possible? We have seen that. Let's remember, this disqualification question has nothing to do with the strength of the underlying case. And we have seen that people have pled guilty and that this, frankly, I think is a strong case. And for a lot of legal watchers, this was arguably the strongest case maybe 6 months ago. Obviously, a lot has happened. Nobody anticipated this disqualification motion and all of the appearance issues that came along with it. But absolutely, the case is going to continue and defendants are going to want to continue to protect themselves.